Good morning, everyone. Just allowing a couple more people in. Good morning and welcome. My name is Shakima Appleton, and I am the Vice President of Webinar Programming for Philly SHRM. We want to thank you for joining today's session, Labor and Employment Law under a New Administration, What Employers Need to Know. During today's presentation, if you have any questions, please feel free to send them via the chat function on your screen, and we will read them aloud at the end of the webcast. We encourage you to choose speaker view for the presentation to allow you the best focus on the speaker. And as a reminder, everyone is currently muted to ensure the best event experience with no distractions. We ask that everyone make sure that their Zoom display name shows their full name. By labeling your display name to be your full name, we will be able to ensure that you receive our post-event survey so that you receive your HRCI and SHRM credits for attending today's event. To rename your display on Zoom, please go to the list of participants at the top of your Zoom window, then hover over your name and click the rename button. Type in your full name and click OK. If you're having any difficulties, please direct message the Philly SHRM participant in the Zoom meeting. If you have not done so already, please follow us on Twitter, Instagram, LinkedIn, and Facebook for the latest updates about these workshop sessions, as well as everything happening within Philly SHRM. In addition, if you're not a member of Philly SHRM, remember that members receive reduced or free event registration, big discounts on the Philly SHRM Symposium, personal connections to the local HR and business community, our members only resource area, including the membership directory, and access to top lawyers and our top leaders in our region. And it's a chance to make a difference in our community. We want to remind you that you are eligible to receive one HR Business HRCR credit, a CI credit, and one SHRM Professional Development credit for attending today's webcast. You will receive a follow-up email after the webcast with a survey link. The survey must be completed for you to receive the certificate for your credits. Once the survey has been completed, the credit forms will be emailed to you within 1 week. Today's webinar will feature Dana Hasness, Labor and Employment Attorney, Employment Attorney at Jackson Lewis. So thank you for joining us for today's webinar, and I'm going to turn it over to Dana.
Good morning, everyone. I'm just going to share my screen for the PowerPoint. So thank you all for joining me today. We are going to discuss labor and employment law under new administration and what employers need to know. I'm Dana Hasness. I'm of counsel at Jackson Lewis here in Philadelphia. I've been practicing for about a decade in the labor and employment sphere. So I've seen a lot of changes and things, I guess, kind of shift. And we'll discuss that today. So here's a little breakdown of our agenda. I'm going to try to keep it to an hour. I know how busy everyone is, but please, feel free to ask questions as they come up and we can address them, like Shakima said, at the end of the presentation. So first, we're going to discuss the history, a historical overview, I guess, pretty much the last 8 years, what we've seen, so then we can discuss what's coming and what we can expect. Some wage and hour law updates, some workplace safety and enforcement trends, specifically OSHA trends, the NLRB union and collective bargaining policies, which I'll mention is probably the most political shifts we'll see, and then anti-discrimination and workplace policies, specifically the EEOC and what we can expect in discrimination laws and similar areas, and then practical steps for employers. So first, a historical overview. So different administrations have different views on labor and employment policies. We saw a lot of pro-employee policies under the Obama administration that were changed under Trump via executive orders. And then we saw President Biden expand those um, workplace regulations. For example, under President Obama, we saw a shift in project labor agreements for federal projects. So basically a construction um, era or construction area focus. Project labor agreements basically set a contract for construction projects, and President Obama instituted executive order or regulation that stated when there's a certain threshold, monetary threshold, project labor agreements need to be put into effect. That was never enforced under President Trump. It was enforced under President Biden, and that's one example of those different political shifts based on party politics and the way that our different administrations kind of see how things should be regulated. We also see, deregulation versus regulation. We're going to discuss that there's going to be a lot of deregulation under the second Trump administration when there was a lot of regulation under President Biden. And then that also comes with pro-business versus pro-worker policies. We, are already seeing a shift that, employers know best. Employers know how to regulate their own employees. They know how to regulate their business versus, the need for policies to support workers. One such example is, the heat regulations under President Biden, where water breaks and meal breaks and things like that were implemented in certain industries for more blue collar type workers. So we can look at those shifts and see that under a Democrat, we're more likely to see those types of regulations. Under a Republican, we're going to see more deregulation in that sense, where the employer knows best. They know how to set policies for their employees. So today we're going to focus on what we can expect in the next 4 years of the second Trump term. First, we'll discuss wage and hour law updates. So the first focus will be on the federal minimum wage and overtime regulations. So we saw under President Biden a shift to increase the salary threshold to around $58,000 as of this past January 2025, which would change employers being able to classify their employees as exempt versus non-exempt. When we're looking at the exempt versus non-exempt regulations under the Department of Labor, the first test is what's the salary? What's the salary threshold? The higher the threshold is, the more likely that we are to see employers being classified as non-exempt and being subject to overtime provisions. During the first Trump administration, we saw that there was kind of a deregulation in how we base that salary threshold test. There wasn't the same parameters that we had seen, such as a cost of living increase every year, and it kind of set a stage where it's going to be a slow and steady increase to allow employers to use more exempt workers, where they just pay them a straight salary based on a 40-hour work week, whether they work more than 40 hours or not. A court recently struck down President Biden's attempt to raise the salary threshold. The salary threshold is now back down to $43,888. And we're likely to see, President Trump and his administration under the Department of Labor do the same thing they did during his first term, kind of set a stage where it's, the increases are going to be very, very slow. They're not going to increase rapidly to match the current, inflation rates or cost of living increases throughout the country. We're also likely to see a shift in the independent contractor versus employee classifications. To be quite honest, a lot of employers unfortunately get this wrong, and they think that, based on what they perceive their employees are doing, that they're independent contractors versus employees. But I'm sure, as you all know, as HR professionals, that we need to look at different tests. Under President Biden, there's a stricter ABC test, which presumes that individuals are employees unless the employer can prove otherwise. It looks like at the Is the worker free from control? Is the work outside the usual course of business? Is the worker customarily engaged in independently established trade? A lot of states, such as New Jersey, still apply the ABC test. But that was what the federal government was applying under President Biden. The less strict test is the economic realities test, and we're likely to see President Trump implement that test again to decide if someone's an independent contractor versus an employee. The economic realities test looks at does the economics of the business depend on what the employee is doing? So is it basically something that the employee is always doing that's customarily part of the business? It's a little more loose, no single factor controls. And for example, in Pennsylvania, we look at different tests, and it's more of a mix of tests. So the important thing here is that we need to consider the state that we're working in addition to the federal tests. But the state will also be important here as well. There are implications for freelancers, gig workers, and traditional businesses. Recently, we've seen a lot of audits, especially in New Jersey, on independent contractors being misclassified. We'll look at different industries that will be affected. For example, gig workers. I worked on an audit recently where a client, they basically do party businesses and they have people do party games, and they thought they were all independent contractors. The state of New Jersey didn't agree because they were not free from control. It could affect, construction, IT, healthcare, real estate, and professional services. We think of, real estate as a perfect example of independent contractors. You come and go as you please. You pay for things for marketing, and it'll really, depend on if President Trump, which he's likely to do, shifts back to the economic realities test, which will keep these industries looking at independent contractors versus as employees. But again, it's important to look at the state test. So if you're in New Jersey, you'll need to abide by the ABC test. If you're in Pennsylvania, you'll need to look at the guidance in Pennsylvania to see if that's changed. It's likely not to. It hasn't in a long time, but it's more of a mix. And, my recommendation, and I'm not just saying this because I'm a lawyer, but is to talk to people in the company. If you have a lawyer, and you can discuss what the person's going to be doing, what their job duties are, to make sure you get it right, because we see these audits going back years and years and years, and fines being assessed in the six figures regarding the differences when there's a misclassification because states want to collect their unemployment compensation that an employer would have to pay if they're an employee. Whereas if someone's an independent contractor, an employer does not have to pay those amounts as part of a payroll tax. So we also will likely see a change in US DOL and state enforcement priorities. So we're already seeing a shift back in the president's utilization of enforcement, but we're not seeing a change in the state regulations or the state enforcement actions. In the last 4 years, we saw many, many, many audits in all different areas, whether it was independent contractors, prevailing wage, failure to pay, and things along those lines. We're likely to still see those at the state, and the state can go back as far as it deems appropriate, but we're not likely to see those in the federal government as much anymore, when we did see an increase in the last 4 years. There will probably be expected shifts in employer compliance obligations based on any executive orders that are issued, but I would be very careful about those, because at the end of the day, if there's a shift back to a more strict regulation or executive order, DOL, whether it's a state DOL, Pennsylvania Department of Labor and Industry, New Jersey DOL, Delaware DOL, they have the right to go back as far as they deem appropriate. During the Biden administration, I saw a small contractor get audited back 30 years for not properly submitting prevailing wage certifications, and an issue with fringe benefits. So even if there's a shift in the federal compliance obligations, we want to make sure that we are doing everything we can to remain compliant in other aspects, given the fact that if there's a shift again, there's a possibility for an audit. Therefore, it's important to prepare for regulatory rollback or new guidance and to be on top of things because every day there's a shift now, especially when it comes to what were the regulations versus what will be the regulations. And then again, it could shift back in 4 years. So just being on top of things is really important when it comes to wage and hour laws and regulations. Again, though, there hasn't been any shift in the actual laws themselves. It's all coming from the executive branch. There's likely to be court challenges, and then that would potentially be the final say, unless there's a shift in laws passed by Congress. Next, we'll discuss workplace safety and enforcement trends. So, what is OSHA's role in the new administration? Again, we're already seeing a push for deregulation versus stricter workplace enforcement. One example is expected changes to COVID-19 and infectious disease workplace guidelines, especially in hospitals. We had specifically different regulations for different types of infectious diseases. Now we're seeing that it's more of a general standard for healthcare. And it's not going to be based on what we're seeing as a community or what we're seeing as a country or what healthcare workers are saying. It's going to be very, very general about how to do certain things under OSHA. We're also seeing regulatory freezes under OSHA in relation to a memo that the Trump administration has put out. And there's been changes to like some workplace hazard regulations given that rollback. And we're likely to see more of it. Again, as I've said, and I'll probably keep reiterating, President Trump views and his administration views that employers know best. They know how to regulate. They know what to do and how to do things for their employees. And they know best as the people that are running a company. Some other changes that we've seen regarding the push for deregulation is, like I mentioned, the heat safety rule has been rolled back, which allowed for water breaks and rest breaks. This wasn't really finalized, but it was definitely being pushed by President Biden, his administration. It's likely to be abandoned by President Trump, but we could see it again in 4 years, depending on who our next president is. We're also seeing a rollback of the walkaround rule, which when there's an OSHA inspection, if the employer is unionized, a union representative was allowed to accompany OSHA inspectors. That will likely be a employer and a union meeting of the minds in the future, maybe part of a collective bargaining agreement, but we've seen that pushback as well. More regulatory rollbacks and compliance changes. We've seen changes to the future of electronics records keeping and reporting requirements. So under President Obama, large employers were required to submit detailed workplace injuries. Under President Trump, that was rolled back. And then under President Biden, it was reinstated and expanded. We're likely to see that rolled back again. Employers, President Trump doesn't want to regulate them. He, again, thinks that they know what's best and doesn't need to keep track of workplace injuries. Again, that doesn't mean that there isn't a right to workers' comp or the employer shouldn't keep track of it. It's just what will be required to be submitted to the federal government and to OSHA. We haven't seen this rollback yet, but it is likely to come. So it's just important for employers themselves to be prepared for that shift and have specific policies in place regarding reporting and how they want to report, and to make sure that if the state requirement for reporting workplace injuries is in place, that they follow that as well. So it's kind of like a puzzle, and what puzzle piece will come next for employers, but it's just the world we're living in right now, and every day is kind of different. But we've seen a big push and rollback in these requirements and a more employer-friendly stance for OSHA, and we're likely to see that come soon, but there's no telling when it will come. So what should employers do in relation to these trends regarding workplace safety and enforcement? prioritize collaboration, make sure that you have strong workplace safety programs through your internal policies, whether that's a shift in your employee handbook or an internal memo or having employees sign off on what their requirements are. You want to make sure that you're doing that, because if someone's injured at work, they have the right to file workers' comp claims. You want to make sure you're doing everything to ensure that those policies are followed and that, someone isn't going to you or to the state OSHA arm and then making a complaint. So it's important that even though the federal regulations are changing, that you as an employer are making sure that you're following state guidelines, state regulations, state laws, and laws that are still in place under OSHA. Again, we're seeing these changes through executive order. We'll see them likely through potential rulemaking at the agency level, but there's nothing that's been changed in Congress yet. So just being aware and making sure that your internal policies are robust is really important. That might also include internal audits, inspecting internally, having a safety officer, if your company requires that, ensuring that, things are done appropriately, and making sure that people aren't subjected to hazardous material, or if there's just even a wet floor, that signs are put out, that there's policies regarding building safety, to ensure that, again, you don't have an audit trigger, you don't have a complaint, you don't face retaliation claims under OSHA, because we think about retaliation in the form of EEOC and discrimination claims. There's a complaint about harassment, hostile work environment, age discrimination, and then someone gets terminated, they're subject to an adverse action, but we forget that it also exists under OSHA. Someone makes a complaint, it's not properly investigated, they're treated differently at work, they can file a claim under OSHA, and that's still very, very much viable. But we are likely to see agency inspections decrease. But again, it's always important to be prepared for those potential inspections, because again, it's probably going to be more about the big fish than the small fish when we look at, employer size and the potential for issues and what OSHA will want to latch on to. The federal government in all agencies was already overwhelmed in its ability to do what it needs to do, whether that's at the labor board or the EEOC, but it's also at OSHA. So getting someone to come out is really important, and to make sure that, we're taking those steps. One example, a client had a complaint about mold in a porta potty on a construction site, and they had OSHA come out and do an investigation. They self-reported to make sure that there were no issues down the road, and OSHA didn't find anything. OSHA might not do that anymore. We just don't know yet. So it's important to think about that. And then if, how you're going to handle that as an employer and what you're going to do, not, because again, something changes, someone decides to constructively discharge, they decide to quit, then they claim retaliation. What do you as an employer want to do to make sure that you're not facing a retaliation claim and being put into litigation? So those are the practical things to really, really think about as these regulations are changing, and there's a lot of deregulation happening in the workplace safety area. Next, we're going to discuss the NLRB union and collective bargaining policies. Before we get started, I will note that this is probably the most volatile area of labor and employment. When it comes to labor relations and labor policy, we see the biggest shifts depending on who is controlling the White House, what party, and what their beliefs are in regard to the ability to unionize. Again, I will note that there has been no change in the NLRA, the National Labor Relations Act. That would take an act of Congress or would take the Supreme Court to strike it down. President Trump, through executive order, can't make changes. However, we've already seen a rollback in a lot of the guidance and policies under the prior administration's general counsel, Jennifer Abruzzo, after she was removed by President Trump. There's already been a rollback of many of the regulations and policies that she instituted while she was general counsel. But again, employees still have the right to unionize, they still have the right to work with unions, they still have the right to collectively bargain. None of that has changed. But what people don't forget, or people do forget as well, is that under the NLRA, employers also have the right not to unionize. So we are looking, that's probably what's going to be guiding President Trump and his administration right now. So currently, the biggest influence by the Trump administration on union rights and organizing efforts is a big shift in the NLRB itself, the National Labor Relations Board. First, we saw President Trump fire the prior general counsel. He then appointed her deputy as the acting general counsel and has since fired her and now has appointed the prior head of the LA office, William Cohen, who wants to focus on more bread and butter issues. So the bigger picture of labor rights, the bigger picture of labor relations. And we've seen him rescind many of Jennifer Abruzzo's policies and guidance. One thing that hasn't been rescinded yet, though, is the joint employer rule, which basically says and I'm sure you all know this, but it basically expanded the idea into labor relations that you can have joint employment. So, you're working with someone or you're working with a third party staffing agency. When we think about traditional employment law, we think about, are they our joint employer? Do we work together? Are we collaborative? Do they have control over the employee like, the employer does? And it's the same thing here. That's been expanded now. We see it again a lot in construction, manufacturing, where we have an owner, a general contractor, and then subs, mechanical contractors, and down the chain. Under the policy of the NLRB, those are all can be considered one employer for liability purposes. So that has not changed. Same with employer collective bargaining obligations and union collective bargaining obligations. If there is an attempt to unionize and the union prevails via an election, everyone must meet at the table and bargain in good faith. So that's still there as well. That's still important. We also did not see a change to the back pay rules that were instituted during the Biden administration in 2023 via NLRB decision that basically anything that that an employee would have been paid had they not been terminated or subjected to an adverse employment action that they can collect if there's a finding in their favor. We've seen extremes of that, but it's pretty much similar to back pay under Title VII, but it can go further than that. I had a matter where someone was sent back to the hiring hall because for lack of work. And then he claimed he couldn't get work in his city through the union and had to drive and pay for hotels. And the NLRB believed that my client was liable for that as part of back pay. So that expanded version of back pay is still good law. It's still precedent under the NLRB. So we have to be cognizant of that. Right now, too, we saw under President Biden that he did not reappoint Lauren McFerrin, who was the chairperson of the National Labor Relations Board. Her term ended at the end of 2024. That left 3 people on the board. The NLRB is a board of 5 individuals. And then he elevated Gwen Wilcox to the chairperson position of the NLRB, and President Trump terminated her, even though her term had not expired yet. And that is playing out in the courts right now as to whether or not she needs to be reinstated. So right now there are 2 members of the NLRB. If Ms. Wilcox is reinstated, President Trump can appoint 2 more people, and that will shift the board to a more conservative leaning, right leaning stance. And that will likely play out for the entire term once those people are appointed. Now, there's a discussion too about the quorum of the board, that there's no quorum right now. And that is true with Ms. Wilcox fighting out her battle in the courts. But there's other mechanisms in order to adjudicate matters with the NLRB. So people can still file with the administrative law judge, or they can file with the office of the executive secretary. So we're not going to see a total halt in the board, but there will be some shifts, and it will probably create more of a backlog, because if there's a decision at a regional level, the appeal process usually is to go or to an ALJ or to the board, depending on what scheme we're looking at and what type of filing we're looking at. So people will have to find employers and employees other mechanisms in the board. So we saw a lot of shifts with union elections and rules and employee rights under President Biden and his administration. One was the quickie election rule, which was reinstated. It set a quicker timeline to go from filing a petition to unionize to the election. It allowed for limited briefing, typically no briefing. And limited hearings on issues of election, and it was just a quicker timeline. One thing we saw was that when a letter was sent to an employer asking for voluntary recognition, if that voluntary recognition there was no response to that letter, then after 2 weeks, the union was voluntarily recognized and the employer couldn't object. And they would have to go to the bargaining table with the union. We also saw limited ability to object to the request for an election. It just was very special circumstances where the NLRB was allowing objections, hearings, and briefing regarding attempts to organize and request for elections. We're likely to see that get rolled back again. It was previously rolled back during the first Trump administration. So we're likely to see more robust employer responses regarding those matters. But again, there's been really no changes in the right to unionize. So employers just need to be aware of what the standards will be, what the standards currently are, what the changes could be, and just really be on top of their game until those rollbacks happen, because they eventually will. And just being aware of, what the obligations are. So for a unionized employee, things are status quo. We follow the collective bargaining agreement. That's what controls our union employees. There's been no changes in what the collective bargaining agreements should allow for, could allow for, will allow for. It's a meeting of the minds. For non-unionized workplaces, employers just really need to be aware of what the requirements are, if there's an attempt to unionize, and if there's any changes. Again, those changes haven't happened yet, but they are likely to happen. And again, how will this impact various industries? So we discussed briefly the rollback of the previous administration's rules. We've seen some smaller rules be rolled back, but nothing that's going to have a major effect yet. What industries will be most affected? Well, what industries typically have unionized employees? We see that a lot in healthcare, construction, manufacturing. And tech. But again, we're seeing a push to unionize in other industries. For example, the Philadelphia Public Defender's Office unionized in the last few years. So are we likely to see that keep happening? Potentially, yes. And the ability to that to happen is always there. I will note that since I started working in the labor relations realm over the last 3 to 4 years, I've been at the bargaining table numerous times. And when it's come to having a new contract, being at the table, we haven't reached a contract during the 1 year certification period. So although we're seeing more attempts to unionize, when there isn't already an established relationship with the union, we're not always seeing a collective bargaining agreement be reached. We're seeing the employers move for decertification, and usually it just depends on the size of the employer and the want of the employees to still want to engage with the union. But I've not seen, actually, despite all of these changes and making it more union friendly, employers and unions reaching a new contract when there isn't already one that's established. For example, we see many employers use associations to negotiate their contracts, but those have been longstanding contracts and those are still in place. But for new contracts, new attempts, we're not always seeing a collective bargaining agreement be reached. So for anyone dealing with those types of issues, although you might be worried, we're not always seeing that come to fruition and a new contract be reached. So therefore, we're still seeing the uptick of union membership attempts to increase it, but it's not always reaching that. and collective bargaining agreements are kind of holding steady, again, if they're already very well established. But the right to seek union membership, the right to seek a collective bargaining agreement has not changed, as the NLRA is still very much intact. And last, we'll discuss anti-discrimination and workplace policies. I know that I'm sure a lot of people are concerned about the attempts to roll back DEI and how that could affect discrimination laws or policies in the workplace. So to date, there have been no changes to Title VII, the Americans with Disabilities Act, the Age Discrimination Employment Act, or any other anti-discrimination laws. We have seen agency rulemaking and enforcement shifting already. For example, the rescission of Executive Order 11246, which limited the ability of OFCCP to audit employers and engage in investigations regarding hiring practices, promotion practices. So as I'm sure many of you are aware, under this executive order, OFCCP was permitted in the long-standing, this executive order was very long-standing from President Johnson to try to meet certain thresholds of hiring racial minorities, women, people with disabilities, and veterans. So President Trump, within, I think it was his first day, maybe 48 hours, rescinded that executive order and limited OFCCP's ability to reach those, goals for gender and race-based hiring, but it did not affect veteran hiring or disability hiring. But we have already seen a shift in those audits and those investigations, and they've kind of, most of them have screeched to a halt. And we're likely to see more of those shifts. In the same executive order that rescinded EO 11246, we saw a big push to eliminate DEI or attempts to eliminate DEI. And but that doesn't mean that employers shouldn't, still have Title VII, the ADA, the ADEA in their minds when they're engaging in hiring, promotions, and different things like that. Obviously, we want to hire, promote the best candidates, and we also want to make sure that we're engaging in lawful practices when we're terminating or putting people on performance improvement plans and engaging in any practices so we don't violate Title VII or any other anti-discrimination laws. But again, those would take an act of Congress. The Supreme Court would have to strike those laws down. And again, there's been no changes in state laws. So when we're looking at, we're in Philadelphia, we're primarily probably talking about Pennsylvania and New Jersey as the states where we have employers in this room. There's been no changes to the fact that you can't discriminate in Pennsylvania, you can't discriminate in New Jersey. The threshold numbers haven't changed to, if you're an employer that's subject to these laws. So that's really important to keep in mind. And I don't think, based on what I've read, what I've seen, that there'll be changes to these laws. It's just, President Trump believes and his administration believes that DEI, which we'll be talking about next, has affected the ability to hire the best candidate because employers are looking at race or gender or other qualifications, protected classes in order to make hiring decisions and promotion decisions. That's probably not necessarily true because again, there's a such thing as reverse discrimination claims, and things like that for failure to hire, failure to promote. But that is the idea that has been in the president's mind, whether right, wrong, or indifferent. So we have seen, a rollback of DEI in the federal government, and we're seeing changes in the private sector. Obviously, there's been an attempt to regulate private sector DEI programs. And typically we wouldn't see that from a Republican administration that believes employers have the right to make their own decisions. But we saw this in the law, sphere, the legal sphere recently with really big AM 50 law firms being scrutinized. And then some, making agreements with the administration and some saying we're not changing our policies. We've also seen a shift in what we call our DEI programs. maybe not calling them DEI anymore, but still having the idea that we want to, have an environment of inclusion and belonging for everyone, no matter what, their race is, their gender, their religion, their, national origin, and making sure we have a welcoming workplace. Um, so again, we want to do that while thinking about the legal risks and compliance considerations. This will all likely play out in a court of law at some point, because again, it's about how far can the federal government reach? Can they reach into the private sector if the private sector isn't actually violating any laws and having these programs? So I would just be aware of that. But at the end of the day, we want to be cognizant of making sure that we're still hiring and engaging in, performance improvement, terminations, in compliance with these anti-discrimination laws, state and federal, to ensure that we are moderate, or keeping our risks minimized, and making sure that we are being smart about, again, how we hire, how we promote diversity, how we terminate people. Most claims that I see in the litigation legal sphere is, why was the person terminated? Why are they claiming? Were there ever any comments made to them? Did they report those comments? How did we monitor things? How did we counsel when there was a complaint, and things like that? So again, to minimize our legal risks based on just, following these anti-discrimination laws. And again, none of that has changed. And then we want to make sure that we have best practices for maintaining inclusive workplaces while staying legally compliant. So, having a very strong reporting policy, having an anti-harassment policy in our handbooks, having a accommodation policy. How do we request an accommodation? How do we hire? How, do we have a progressive discipline policy? When can we step outside that progressive discipline policy? And just being smart about putting things in writing and making sure that we're following those policies to avoid, issues down the road. So I'm a big proponent of, strong handbook policies and making sure that people are aware, and training and making sure they're trained, on how to deal with complaints and managing our employees and who to report issues to. We just don't want managers saying, well, you're not doing a good job, so I'm going to write you up. We want HR to be part of that. You are all experts on these matters in your places of employment. And then, another big area we're seeing is religious and political expression in the workplace. So how do we manage people's religious rights while maintaining a neutral workplace? We definitely are seeing a push by the Trump administration to make sure people can express their religion, and express it, how they see fit, take time off for religious holidays and things like that. So, and there might be a focus on one religion under the administration, but we have to make sure that applies to all religions. We live in a very volatile world right now where, expression might be seen as offensive when it really shouldn't be. So how do we manage all of those things? And then again, also, how does that play into free speech? How does free speech generally play in the workplace while maintaining a neutral workplace? Again, it's okay for people to voice their opinions, but where do we draw the line? How do we balance those issues? We want to make sure that, also when it comes to social media, do we have a policy that if, on LinkedIn, for example, if you're talking about an issue, what is that issue? How is that going to reflect on the employer? We want to make sure that we're keeping neutrality as much as possible. And how far can we reach? Do we have precedent on how we can control speech in social media? Again, that's something to think about. And before I move on to the practical steps for employers, I think right now the biggest issue we're likely to see in changes to anti-discrimination laws is we saw a big expansion of rights for, LGBTQ plus rights, and what are we going to see that roll back? We're already seeing an attempt in the federal government to roll back transgender rights. How will laws be affected? Will laws be passed? Will Trump issue something that can affect those rights? For example, the biggest, thing, I guess, over the last 5, 6, 7, 8 years was, bathrooms and how we, are we having gender neutral bathrooms and things like that? And what will the government try to do to roll back those policies? We saw, for example, in Title VII, gender identity being part of gender-based harassment, gender-based discrimination, and it fell under there. So will the Trump administration try to change that? Will Congress try to pass a law rolling that back? We haven't seen it yet, but that's likely the first push to make changes in this area. We're also likely to see, we saw the EEOC, one of the chair people get fired. Again, that will likely play out in courts. We're not likely to see many changes in the EEOC, though. The EEOC, most states, again, New Jersey does not have this under state law, but Pennsylvania does, where we're required to file an administrative complaint before going to court. And I think the biggest change will be whether the EEOC decides to litigate a claim on someone's behalf. They've always just done the bigger claims, a bigger issue, a bigger fish, a big company, and that will likely stay the same. But we're probably likely to see less investigations, less enforcement, less hearings. And then just more right to sue letters so people can go right to court, and it'll probably be around the 180-day mark. It doesn't mean that there will be a change in state, enforcement. That will likely stay the same. We see a lot of in the Pennsylvania Human Relations Committee, a lot of investigations, a lot of interviews and things like that. That's likely not to change. So I think the biggest change at this point will be how are transgender rights looked at? Will there be another rollback on, bisexual, gay, lesbian rights? That might be the next push after, considering that we've already seen a push, for that. The Supreme Court did, grant a lot of rights in the, last 10 years, and gender, gay rights was included under Title VII. No, discrimination based on sexual orientation. That likely won't, get overturned in the near future, but there might be a push for that. So what can employers do during these uncertain times? We want to make sure we're compliant. We want to make sure that we have strategies in place for shifts and how you as private employers are going to handle those changes. I would consult with, an attorney. I would consult with, counsel on a lot of those matters, to just try to really tighten up policies and figure out what we're going to do if there's changes and if, there's an attempt to shift the private sector. The best place to start is through policy and handbook updates. A lot of the times our handbooks are pretty generic in a sense where, just because there's a big shift federally, we don't have to make a change. But just making sure that those are up to date and making sure they reflect what you as employers believe you should be. Your handbook is what you provide to your employees. How do you see these changes affecting that, if at all? It might not. So that's something to definitely consider. And then just preparing for regulatory uncertainty, and being aware of the changes that could come. How do we want to address that? How do we want to handle that? And then, making sure that we're aware. Right now, we're seeing a big picture change. And that might not affect, things. Again, I'll go back to the break rule policy for people that are out in the heat. You might still give breaks. There's no requirement in Pennsylvania to provide breaks at all. For example, the federal government had those requirements. You as an employer might decide, I want to give everyone a 15-minute break, and then a 30-minute break for lunch, and that might not shift. So just trying to figure out what you as an employer, your beliefs are, your ideals are, and how you want to treat your employees is, the most important thing at this point, and then reflecting that in a handbook update or new policy updates and making sure that you're just on top of things and asking questions to the people that you need to ask questions of, if any changes are necessary per an HR point of view. So with that, I actually, came in a little bit under, so we have some time for questions. Does anyone have any questions?
Hey, Dana. So someone popped something in the chat if you want to check it. Deborah Young. She
Okay.
popped a comment.
Okay, so this says my firm recently rolled out bonus guidelines for managers and above. There were 5 points, including one that addressed actively promoting DEI. When I asked about this in light of the executive order, I was told that we are doubling down on DEI. If it wasn't actively promoted, it wouldn't affect bonus eligibility, but it could affect compensation. This sounds risky to me. So as a private sector, business, they have the right to do that. It's the thing, in my opinion, is it's really difficult when it sounds like it's a discretionary bonus and discretionary bonus guidelines versus non-discretionary. So when we have a discretionary bonus, it's what boxes are you checking, what's your performance look like versus what metrics are you meeting, and if you're meeting these metrics, you're guaranteed a bonus. But we want to make sure that we're not just looking at things in the DEI realm that are just, putting people into a box. That's where the risk comes from. For example, I'll use, I guess, I hate to say it this way, the clearest examples. So you have two people going up for a promotion. One's a white male, one's a Black woman. And the Black woman is more than qualified, been at the company for 10 years. The white male's been at the company for 8. They both serve in the same position currently. And but she checks off more boxes. We want to make sure that we're looking at it from an objective, point of view. What boxes is she checking off for this job? What has she done recently? And versus what he's done recently, what boxes is he checking off to avoid a claim? Whoever they would, hire or promote, we want to make sure that we're not, facing a claim because we were looking at, diversity only or equality only. We want to make sure that we're looking at them as a full candidate and what they bring to the table. Maybe he serves on numerous committees at the company and has really been pushing forward something great, worked on a big project and really made it happen in a shorter time frame, under cost, things like that. Maybe she's done something similar, but who fits this role the best? Who, I guess, maybe is better with other people, promotes a more inclusive environment, is more of a team player. So we want to look at it more objectively than subjectively, like, okay, she checks the box of 2 protected classes, let's promote her. So that's where the risk would lie. It's, we can double down on DEI, but it's about how we double down on DEI and what we're looking at here. We're not just looking to check a box to have a diverse candidate to fill a need. We're looking at the best candidate who brings the most to the table and explaining, to them what we're looking for and what we need in the job. It's about more of the league. I'm not worried about it from the precision of the executive orders. I'm worried about it more from a Title VII point of view or an anti-discrimination law point of view and limiting legal risks. And that's what my recommendation would be. We don't want to just have DEI to check a box. We want to have it because we want a diverse workplace. We want an inclusive workplace. We want equality and equity in our people. We don't just want to check a box because we don't have enough Asian American employees who are managers or enough Black employees who are managers or whatever it might be. We want to make sure that we're just looking at the whole picture of the person. And there's ways to double down and still do that without creating a lot of legal risk. And so I would just be cognizant of that and, asking those questions as to how they want you to promote DEI, how they want you to double down. What are we looking at here? And again, if it's about checking a box, that's where the risk lies.
Thank you, Dana. If there's any more questions, you can pop them in the chat or you can come off mute. We'll wait a couple more seconds for folks to chime in. All right. So if that is all the questions for today, I would like to thank you all for joining us for today's webcast. Dana, thank you so much for this informative webcast. And as a reminder, please look out for the follow-up email with the link to the survey and be sure to complete the survey in order to receive your HRCI and SHRM credits. On behalf of Philly SHRM, thanks again and enjoy your rest of your day.
Thank you, everyone. And if you do think of any questions afterwards, my email is on the first slide. It's dana.hasness@jacksonlewis.com. I hope that this was informative, and I know that you're dealing with a lot of turbulence right now, but hopefully things come smoother and, even out, and you're not dealing with different fires every day and trying to figure out the next steps. I know HR isn't easy, so I commend all of you for dealing with it on a daily basis.
Thank you so much, Dana.